um, so this is something that we put together especially for business owners to at least have a good foundation when it comes to the legal aspect of running a business. And this year, we've started speaking specifically about contracts and how to structure your contracts, how to draft those contracts, and how to execute those contracts effectively as a business owner. And today we have with us a very seasoned legal professional by the name of Abba Victor Uche. And as I usually do, I'll just tell you a bit about him, and I'll then hand over to Victor to let us know what he has for us today. And today's topic is going to be about intellectual property and contractual safeguards, the use of special clauses. And just to give you a little background of about Victor Uche, he's a dynamic legal professional with a core expertise in corporate and commercial law, intellectual property, and technology law. He's also a trained data protection officer with a strong commitment to helping businesses navigate regulatory frameworks while protecting innovation and digital assets. He's currently serving as a managing associate at Olive Vine Attorneys and advises startups, creatives, and tech-driven companies on IP protection, contract structuring, data compliance, and strategic legal positioning. His experience spans from drafting solid commercial agreements to offering legal frameworks that enable growth and security for innovative businesses. He's very passionate about simplifying complex legal concepts and often speaks, writes, and consults on how startups can safeguard and monetize their IP. He combines a creative flair with legal precision and helps brands and founders thrive in today's competitive market. So beyond the boardroom, Victor actively contributes to thought leadership through his social platforms. And I'm sure in the course of the presentation, you see exactly where to find or how to contact him on social media. Um, and he offers seminars offering practical guidance on IP law, tech compliance, and digital policy. He's a member of the Nigerian Bar Association, FinTech Nigeria, and MIPLG, where he actively serves in various capacities to foster legal and technological development in the country. So you can find him with the handle Abba Victor Uche on all social media platforms. Okay, so without saying too much, I'd like to give the floor to Mr. Victor. If you can kindly put on your camera, sir, so we can see your face and hear from you.
Hey, thank you very much, sir. Um, I thank you very much, sir, for that um, presentation. I really appreciate. I find it a privilege to be speaking um, to everyone this evening. Um, please just confirm if you can hear me. Okay.
Yes.
Uh, thank you very much. Um, Not to waste time, I'll just go into the subject matter for today. As much as possible, I would go because I believe the is the basis of communication. So, but just before then, I'd like to know. Um, okay, okay. So I'd like to know the demography of the audience. I'd just like to know um, the persons that actually make up the audience, so that I know how to tilt my talk. However, I already have a slide prepared from which I will be speaking from. So, but if it is possible, just use the chat box to tell me what you do, either as an occupation or as work. So, if you're a trader, just let me know. If you're a lawyer, just also let me know. While you do that, let me just use this opportunity to celebrate the World Intellectual Property Day, which is today, and I find intellectual property very interesting, and it's something I actually do take personal at times. Um, so so I'm still waiting just to see because it would help me in putting out some of my thoughts and experiences to you this evening. So just let me know what you do for work or what you do um as a business. I'll be looking at the chat box while I dive into what I would have to do this evening. Thank you very much for having me. I really appreciate this opportunity. Yes. Okay. So I just got like two replies. Lawyer, legal tech company. Okay, that's nice. Nice, nice. So for the lawyers, pardon me, I might not be using um, I might not be using so much of those words. And it's just very intentional. My intention is for us to understand. So I would use simple words as much as possible, just so that we grasp everything that is being said. Yes. So I'll be looking out. I'll be looking at the chat to also get more responses. Okay, lawyer from okay, okay from Alabi. Okay, that's nice. I think we have a lot of lawyers around. Okay. So just permit me to start already. This evening I'll be speaking on intellectual property and okay, from Victoria, I'm a company secretary, but not a lawyer. Okay, that's nice. Okay, it's nice meeting you, Victoria. Okay, so I'll just keep looking at the chat box while I talk. Um, just keep updating whatsoever you do on the chat box. That will really help me in tilting my thoughts and just trying to communicate. Okay, so tonight I'll be speaking on intellectual property and contractual safeguards, the use of special clauses, um, like the the convener said, um, businesses are actually in focus at German Legal because one of the objectives of this webinar is to as much as possible have business owners comprehend some of these legal jargons in the simple way as much as possible so that they appreciate them and apply them when necessary for their businesses. So tonight we'll be talking around contracts. We'll be talking around contracts, but especially within the scope of intellectual property. Now, just for a foundation, just for a foundation, please, if you are just coming into the call, you can just do well to mute your mic. You can just do well to mute your mic so that we don't have any distraction. So, just as a background, we understand that for a contract to happen, there are certain ingredients that must actually happen. Now, these ingredients include offer, acceptance, consideration, and intention to actually create a legal relation. In basic terms, it just means that at least two people have to come together to actually agree based on certain terms that they want to do business or they want to carry out a particular transaction. That transaction may include, but are not limited to marriage, to business, to just whatsoever it is. Two people coming together at least to just say, okay, let us carry out this stuff. And of course, because we are speaking around legal circles, we would want to make sure that whatsoever they agree on is actually legal. So in this instance, we're not saying they are trying to come together or they are trying to plan an ambush to kill someone. No, that's not what we're talking about. We're talking about contracts that are tilted towards transaction, business, and then something legal that meets, of course, the needs of, of the target audience, and of course, have some returns in terms of earnings and, of course, compensations. Um, I'll just dive in. Just can I have the second slide? Yes. The reason why I decided to just start definitions is because I would want the very big terms. Of course, I know intellectual property is not a big term; it's a common word. Um, Coincidentally, today is the World Intellectual Property Day, so I'm very sure that if you have been scrolling through social media, you must have seen the word maybe once or twice. Now, intellectual property is a compound word made up of two words, intellectual and property. So in very simple terms, it just covers the creation of the mind. Um, and because it is intellectual property, there's a restriction to these creations. It means that creations from every other thing will be excluded from this definition because our concern now with the creations from a human being per se.
Okay, I think um, there's a bit of Victor is facing a little technical issue. If you can kind of just give him a little time to come back. And by the way, those that haven't let us know in the chat, please let us know in the chat what you do so we have an idea of who we are speaking with. And once again, try as much as possible to keep your mics and cameras off so that there's no disruptions in the presentation. We'll be posting a link soon where you can mark your attendance, like we always do, so that we know who attended and how to send out your certificates for participation. Okay, so I'm just curious. I'm seeing a few people in the room now. Um, Now, before you came, we were putting in information about what we do. Umar Suleiman, could you just tell us in the chat what you do? Ebele, Innocent, Bikakoy, Abimbola. I don't know who is iPhone 11, but if you can also just let us know your name and what you do, that would be amazing. Okay, Tracy Peters, wonderful. So let's just know on the chat what you do. Tracy Peters is a lawyer. Umar Suleiman is an accountant and also a farmer in general. That's wonderful. And while you do that, there's something that we had spoken about in our previous workshops, which is it's like a little test that we've put together that helps us understand um, uh, what your areas of legal need are within your business. Okay, so if you're running a business and um, you look at the structure of your business, we would like to get to know how that structure works and how the legal aspects of your business actually currently operates. If there's areas where you need assistance, it'll be easy for us to know through that test how to assist you. Um, yeah, so I'm going to put the link on the chat now. But you can just go to ramen.legal/legal health test. Let me just confirm that quickly. In the meantime, as well, we have a few lawyers in our midst. I'm going to call on Precious. She's one of our in-house lawyers to give us a bit of a.
Uh, yeah.
Okay,
Sorry,
okay,
sorry about that glitch. I didn't even know when I left the call. Sorry.
that's fine.
Um,
Okay,
okay.
you
Yeah.
carry on.
So, yeah, I think we should. Yes. Thank you very much. So like I was saying, intellectual property, IP for short, is classified into various types. The classification is actually more than this. But for the sake of this conversation, we'll just be looking at some of these very basic ones. And this for obvious reasons.
Mango. Ọkàn wọlé tí
Obvious
tiẹ̀ dá sí.
reasons.
Báwọn gan ni comfortable wọn ṣe wà.
Okay, this is for obvious reasons around that. This is for obvious reasons around the fact that through my experience as a lawyer and even from precedents, these classes of IP actually are very common, and we actually do have some form of legal framework, sort of for all these ones listed. So first we have copyright. Copyright, which is like a very broad classification of IP, covers for literary works, covers for artistic works, covers for music, and every other work around things that are being created, like books, written works, articles, and all those other stuff. So copyrights, of course, can also be called automatic rights because once we can be sure that okay, this work is original, was made by the person, and then such a work is being put in a fixed form, in a form that can be transferred. Um, then then we can say that okay, you have copyright over that work. Then also we have trademarks. Trademarks and patents are actually industrial rights actually. So trademarks covers for identifiers. By identifiers now, I mean every other thing that you can use to identify your brand or your business. This means that and this includes your logo. This also includes your. Sorry, can you guys hear me? Sorry, can you hear me?
Yes, we can.
Okay, okay, okay. I just wanted to confirm that. Okay, thank you very much. Yeah, so trademark covers for identifiers, basically for your brand. That is your names, logos, and every other identifier, basically, that your business owns. So there's a clear legal framework for that protects every other thing that identifies your business or whatsoever it is that you produce. Also, we have patents. Although this leans more towards the technical industry. Of course, we can also find it in other industries, but it leans towards innovations, inventions, and of course, there are parameters to actually check to know if okay, this item is actually patentable in that instance. It's actually a right given to inventions that are of course novel, that are of course actually that can be reproduced in an industrial setting and all those stuff. Trade secrets would also fall under every other information that makes for a competitive advantage. Of course, every other information might not pass for a trade secret, but something that has commercial value will pass for a trade secret. Although we do not obviously have like a law, like a trade secret act or a law that says, okay, so, that says expressly or that guides trade secrets, especially here in Nigeria. However, it is important to note that trade secrets actually do exist and they form a major part of the intellectual properties that we are going to be talking about today. So every other information that makes up for a competitive advantage. These informations could be formulas, they could be the way you serve your clients, they could just be any information that makes for a competitive advantage would fall under a trade secret. Can we move to the next slide? Now, intellectual property is very important because it actually forms a major part of whatsoever you are building. Um, Whatsoever business you're building, it forms a major part of that. It is like an integral part. Most of my work as a legal practitioner falls, you would understand. Those in the tech industry do a lot of creative work. They come up with a lot of products and all those other stuff. So it is even very important that we understand that intellectual property comes really really handy in a case like this, and that's why we're trying to look at ways to actually try to bind some of these assets, this intellectual property assets, to the rightful owner. Now, just to take us back a little bit before we fall directly into the key elements of a legal contract or those clauses that actually help a business owner or a creator to actually protect their intellectual property assets. It is also important to note that the intellectual property of any business is the business itself. When companies would want to do their evaluations, when companies would want to sell off in that sense, um, among other things that they value is their intellectual property assets. And that is why it is important to actually pay attention to some of these assets, even as a business owner. Yeah, so sorry about the noise. Um, sorry about the noise. I think it's better now. So so to just dive in to some of these key elements of a legal contract. Now, like I said earlier, when two or more people come together to agree to say, okay, let us do business together, let us enter into a transaction. the next thing they would want to do is to outline certain terms that they would want to abide by during the course of the transaction. It is not advisable to enter into any contract or any business that runs on an oral agreement system. It's not advisable. Of course, an oral system um, doing doing business or an oral form of agreement actually works, but it is not advisable. And this is why. It is because you need to make references later. Now, let me just go a bit faster than myself. Later in the course of this talk, I would show you how that when contracts are being drafted, they are not being drafted for the immediate. They are being drafted for unforeseen, like for uncertainties. Now, I would advise you properly as we go on that each time a contract is being drafted, it should be drafted as though you'd stand one day with that contract and present it before a judge in a court or in any other dispute resolution setting to actually defend whatsoever is on that contract. Yes. So with that in mind, we'll just look at some of the key elements of a legal contract. This list is actually inexhaustible, but for the purpose of this talk, we're just picking out some of them. Now, the first one you want to look at is the title and parties. Now, from the title of any contract or any agreement paper, you would actually be able to decipher what type of agreement that is or what type of contract that is. If a legal contract says or is called a sale of land agreement, for instance, your mind quickly tilts to the fact that such an agreement is actually for the sale of land. If you see an MOU, for instance, it just means that okay, there is some sort of understanding between parties. If you see, so somehow the title of any document or any contract sort of gives you an idea of what that contract is about. Also, apart from that, it also dictates the parties to be involved in such a contract. So, for instance, in a sale of land, what you have is in a sales agreement, for instance, you can have party one as the vendor, that is the person selling, and then you can also have the purchaser, that's the person actually buying. So the title or the contract itself determines what type of parties will be included in such a contract, and that's very important, something that we should all know. Also, there is the offer and the acceptance side of things. Now, it just means that in an agreement, it just means that one party is offering something and the other is accepting that offer. Like I stated initially when I started, I said there are key essentials of any contract. They are key essentials of any contract. And I stated how that offer, acceptance, consideration, and then an intention to create legal relations actually are some of these essential elements or essential parts of a contract. We must see some of these things or all of these things before we say, okay, the contract actually happened. Now, the consideration part, somebody saying something. Okay. So so the constitution part is very important. This is one of the aspects of any contract that you want to look at very carefully, because it just specifies to you how much is involved in that contract. And there are barely few contracts that actually have this part. Like almost all the contracts or most of the contracts will have a consideration clause, an element of consideration whereby there's an exchange of money, there's an exchange of services, there's an exchange of goods of some sort. Now, this is very important because it shows this is the value side of that contract. This is where you now know, okay, how much this contract is worth and all those stuff. And sometimes for we as lawyers, that is how we actually know our 10%. That is just for a that's just in a lighter note stuff. But it's a very important part of any contract that you're actually working on, even as a business owner. Um, then there's the mutual intention. both parties must intend to be legally bound. So basically, of course, like what we have been saying, there must be some sort of agreement, and that agreement must be clearly specified. That okay, party A intends to enter into a legal relation with this concerning this and all those stuff. So the subject of the contract must be stated. Um, the agreement upon which the agreement, sorry, the subject upon which the agreement is founded must also be stated. Next slide, please. Can we have the next slide, please? Okay, thank you very much. Yes. So no, not okay. So this, yes. So basically, this, like I said already, these essentials or these features of a contract are actually very inexhaustible. So but we're just going to be picking a few of them. Now, and I'll be picking this just very quickly so that we just leave out and then go into the subject matter properly. I'm just trying to lay some foundation for a contract, and then I'm sure we're already conversant with some of these things, but just to lay proper foundation for what we're talking about. So governing law, I've seen contracts. I've been in situations where I had to review contracts without a governing law, and I'm like, okay, so what law do you intend to have this contract being run by, or what law do you intend to actually have that this contract be read according to? So the governing law is very important because even as we're talking about intellectual property, there are legal frameworks that are not presently active in the country as to intellectual property that might be very active in. What the governing law does is that it specifies under what jurisdiction that the contract is enforceable. So if you actually sign a contract that has a governing law within Nigeria, that contract might not be enforceable outside Nigeria. It means that only the laws of Nigeria would guide the application or the enforcement capacity. Of course, we all know obviously that an adult, of course, spanning within the age of say 16 years upwards can actually enter into a legal contract, depending, of course, on certain parameters. Also, we want to know because there's bound to be some rifts. There's bound to be disagreement in certain points. Now, this clause is not just there because we're anticipating dispute. It is there because it's very important. A dispute in any contract is very inevitable, and it's just very important that you have that clause there to actually check. You actually check things when these disputes come in place. Now, for instance, in a co-founders or a founders agreement, you'd find out that an exit strategy or an exit clause is very important because what now happens when a particular co-founder or a party in that contract intends to leave the transaction or leave the agreement or leave whatsoever it is, there has to be some clause to just cover for that. This just shows that a contract is just a piece of paper. Allow me to use that. It's a piece of paper that contains every other thing that should happen within that transaction. Also permits me to add that duration is also important. How long the contract will take? Will it be 2 months? Will it be 2 years? Will it be forever? And all those other stuff. I'd like to have the next slide now. Yeah, so I just hope I'm being very clear as much as possible. Can I have the next slide, please? Yes, thank you very much. So like I have already established how that intellectual property is like the business itself, is like at the heart of the business because it covers very important assets of the business. So I'll be using certain examples and just to actually bring home the entire idea of why it is actually important to protect the intellectual property side of things of the business. Of course, you can't just have the IP just standing alone. There are other. Oh, sorry about that. Clauses that make section. How do we then use this our contract paper to actually make sure that some of these intellectual property assets that we have in our businesses, that we have in whatsoever we're building, is being protected? Because once you lose your intellectual property, you have lost the business entirely. Um, and then this is just very important. So the first one we'll be looking at is the IP ownership. You'd just want to know who owns the intellectual property. There's this general law. We have a framework for in here in Nigeria that states that in an instance where an employee creates something or like come up with an invention during the course of his employment, the intellectual property in that invention belongs to his employer. That just of course there are exceptions, but that just simply means that if he does something during his work hours, if he does something using the tools of his employer, it means that the IP in that stuff that he has created belongs to his employer. Now, what a contract will do for you, except, or of course, except among other things, except if there was an agreement stating otherwise. It's just like a photographer now. Once a photographer takes you a picture, the IP in that picture belongs to him and not to you necessarily. Doesn't even matter if you are the one in the picture, it belongs to him. Except there's an agreement saying that okay, this IP rights belongs to you or is being shared. Now you want to clearly state who owns the intellectual property, and this can be done very clearly by having an intellectual property clause on your contract paper. You want to say, okay, party A owns the intellectual property in this transaction or in this product or in this item that is being built or that is being the subject of the transaction. It could be anything. It could be a product. It could be a book. It could be a software. It could just be anything. So next up is confidentiality. Now, confidentiality is very important, and this falls more under or leans towards the trade secrets I was talking about. Now, companies or brands usually have specific informations that they find very financial worthy. By that, I mean they find to be of a competitive edge or that they find to be of some sort of advantage to them. There are certain informations that um, companies like Coca-Cola have had for many years now that form that form please can you mute your mic, that form a thank you very much, that form a that form part of their successes or that form like a competitive edge for them. um these informations could range from formulas, from 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 data, just stuff that they have kept for so long. Now, it just means that such trade secrets or such information will lose their value once they enter into the public domain. Sorry. Once people get to know about them, they actually lose their value. And such information must have some form of monetary value, commercial value. Um, Hiding that you wear a pink socks, for instance, as a business owner, when that does not directly form any commercial advantage or commercial value to your business, might not really form a trade secret. It might just be something else. So for confidentiality, one of the very common documents or common agreement you'd want to do in that instance, or clause you'd want to include in your agreement, is the non-disclosure agreement. Um, while it is very possible to have a separate document for your non-disclosure agreement, it is also advisable to have it in your general agreement, so to say. Now, what the NDA does, is that it makes sure it just makes sure that those proprietary informations are not, or information rather, sorry, are not being shared to third parties not included in the agreement. It just means that, okay, members of that or parties to that agreement, which may include the employees, co-founders, and every other person that have access to such information, would not spill out those information. So I mean, I think history has it that companies like Coca-Cola have had some of these their trade secrets kept for a number of years now, and that has made them a lot of advantage. So very quickly, um, we'll now look at the clause of assignment and license. Now, this is very important. Now, I'll just explain this in very, very simple terms. Now, assignment talks of outright sale. So it's just like you're trying to sell the IP directly. You're saying you're assigning your IP to this person. So it means that you lose every right to that intellectual property. You want to state clearly that, okay, this intellectual property rights that I have, I am passing it down. Of course, we understand that intellectual property rights are intangible rights. They are not things you can see and touch. They are not like land that you can sell and then see it physically. They're actually intangible, and that's why they are even very dicey to manage. And it is because of that that we have this special clauses to actually tie things down, so that if any issue comes up, you can easily just you can easily just reference some of these clauses in your agreement and say, okay, I did not actually sell this intellectual property to party B. What I did was that I licensed it. Now, in the case of license, it just means that, okay, you are allowing the other party to use your intellectual property based on certain agreement or for a period of time. Now, in that instance, you might want to say assignment is like selling your intellectual property, like you sell land, and licensing is like renting it out, some sort of. So you still own the intellectual property, but you just allow it to be used by some other person for a particular period of time and based on certain agreements. So lastly, there is the moral rights waiver. This is not so common, but this is also important. And this allows for modification or use without the creator's consent. Now, under copyright, copyright is very interesting because it's broad. I think it's one of the broadest classification of intellectual property. And moral rights, sorry, and what copyright seeks to protect. It seeks to ensure, like every other, like, of course, like every other classification of intellectual property, it seeks to ensure that the creator actually enjoys two kinds of rights, which I would like to style moral rights and then the commercial or monetary rights. Now, these moral rights includes things like reputation, goodwill, and all those other stuff. And then the commercial rights, which is obviously the monetary rights part of things, now talks of the financial aspect of things. So it seeks to protect these two strands of rights. Now, this moral rights waiver just would show you clearly on the agreement paper that, okay, I'm actually waiving some of these my rights, and I'm not in any way I'm not in any way restricting you to use it. Now, what this clause does to you is that it says, okay, you can actually use this without my consent and all those stuff. So you'd want to make sure next time that whenever you have an IP and intellectual property involved in the transaction you're doing, you clearly have all these clauses clearly stated. You'd have to highlight some of these clauses or all these clauses so that you actually know where you're headed to as to your intellectual property. Can we go to the next slide? My time is running out already. Now, I think I already explained some of this previously. So I think we just move on. We just move on. Let's move on. Yeah, let's move on. Exactly. I already also stated this. So this now expounds what I was trying to talk about, the non-disclosure agreement. Now, the non-disclosure agreement is very important that even during some transactions, doing some transactions. Doing some transactions, and like I've experienced through my practice, certain transactions would actually make for the make for a non-disclosure agreement to be done separately from the main agreement, and that is because the intellectual property asset in that product or in that transaction is very important, and they just want to tie up things. Now, like I've said before, the non-disclosure agreement would actually have to clearly define all of the all of the confidential information that is involved in that transaction. Of course, it will also specify duration. You could have duration as long as 3 years, 5 years, and just ranging like that, depending on, of course, the agreement. You could also have, or you should also have rather, those obligations. Of course, what is a contract without obligations? What is a contract without having to know what each party is supposed to do? And then, of course, consequences. Now, these consequences would include, and this is where the dispute resolution comes in. So what this is basically saying is that those non-disclosure or confidentiality clauses must be involved in actually protecting those intellectual property assets that are being found in your startup or in your business. Can we just move further? The reason why I rush this is because I have briefly explained it. I've also explained this, but just for emphasis, like I stated, you'd want to state clearly, and this is very important because your contract paper or your agreement paper now, if you permit me, is not something that you'd want to make ambiguous. You want to be as clear as possible. You want to state whether or not you are selling the intellectual property or you are licensing it out. If you are selling it and you're doing an assignment, it means that your rights to that intellectual property has ceased, or you are licensing it, it means that, okay, you're giving it out for a particular period of time based on certain terms and you intend to get it back. Yeah, so that's how this works. So my advice now is that you draft your assignment clauses and your licensing or your license clauses very clearly, and make it as exclusive as much as possible. Just make it very clear as possible so that there's no ambiguity of such. Can we go to the next slide? Yes. Um, so I have here on my slide some common IP clauses or mistakes that actually people make. Now, there are usually very vague definitions and unclear IP terms that actually causes dispute. Now, as much as possible, when you're drafting your agreement or your contract, you want to make sure that those clauses that actually protect your intellectual property are as clear as possible. And this applies to every other clause. Now, the reason why the intellectual property clauses are highlighted, it doesn't mean that they are more important. It just means that they are important. Of course, not more important, but they are actually important because they make up for a good percentage of everything that the transaction is about. So you want to make sure that as much as possible, the words that you use, every other thing is clear as much as possible. Now, future rights, failing to secure rights to future work. Now, like I said earlier, I actually do a lot of work at my firm. That's Oliver and Athens. We do a lot of work around for tech startups, and we we actually have reviewed, of course, a lot of agreements and all those kind of stuff. So through my experience, I have noticed that that startups or founders are not actually careful to note the extent to which they're actually protecting their IP. Some believe that the agreement is just a one-time off, and like I usually would say, there's no agreement that is one time off, except that is actually stated in the agreement, and an agreement is actually limited by the clauses in it. So an agreement is actually limited by the clauses. So if, for instance, the agreement does not even state or does not have a duration clause, then you'd want to be you'd probably be shooting yourself on the foot, because this is very important. It just shows that you need to indicate how long the IP right should subsist, and this brings me to whether you are licensing it out or you're actually selling it. Also, they actually overboard terms. Now, confidentiality clauses that are too broad. Now, this is just like the first common mistake that I highlighted. Um, some of these clauses, and I see this mistake very commonly. Some of these mistakes are sorry, some of these clauses are actually just too broad. They are not very specific. They look like they are trying to cover the field, but at the same time, they are not doing the work. They are not cutting it at all. So you want to make sure you are as concise and as clear as possible. Okay, so if what you are coming up with is a product, you want to make sure that the specific information that you are trying to keep confidential, or the specific information that you are trying to actually have as a trade secret are actually clearly stated. If they are formulas, you state them clearly, and that is one of the reasons why a definition clause on the agreement is very important, because it actually highlights some of these things. It gives like a broad definition for some of the terms you'd be seeing through your contract. The fourth one we have here is jurisdiction issues. Now, another issue is the issue of jurisdiction. Like I stated sometime earlier, the laws in Nigeria are not the same with the laws in the US. Um, and that is because law in itself is actually is jurisdictional. Actually, you can't have the same laws everywhere. So you want to be clear with what laws are to cover for your agreement. If it's the law of Nigeria, you have to be sure that you are conversant, and you have to make sure that the laws of Nigeria actually protect that asset or that IP asset that you're actually claiming you want to protect. So these are some of the mistakes. And in an instance where you have a cross jurisdiction, like where you are doing business with somebody over in another country, you also want to clearly state this, that okay, um that the laws of both countries, or that the laws of the parties of these countries would actually apply in case of any dispute and all those other stuff. This will actually save you from unnecessary disputes and all those issues that might arise. So can we go to the next slide? Yes. So as a conclusion, I'll just put it out there that as much as possible, you just draft your transactions, you draft your contract, draft your contract rather, um, for transactions the with the intellectual property assets in mind. Now, me for one, I believe that almost every business have some form of intellectual property asset that is just looking around. It's probably that it's very possible you have not seen it, but it's just there. So as much as possible during every transaction, if you have to come up with a contract, you just make sure that you want to protect all the IP assets that you need, and that's why a lawyer is important to help with intellectual property audits, to make sure that okay, these intellectual properties are actually being protected, and we know who and who owns what. So, of course, like I've already stated, use key clauses. This cannot be overemphasized. I think this is like the center of everything we've been talking about. Using clauses to actually just protect the intellectual property asset. This is very important, because this is like the brain of everything. And then lastly, of course, you don't want to do this alone. In as much as contract can actually be generated using artificial intelligence, of course, there is that side where you need to hand over such contract to an expert, um, mostly a, a legal practitioner, to just help you look through it and then make sure that these stuffs actually align with the laws of the relevant jurisdiction, or the relevant place where such a transaction is taking place. And this is very important. Like, this is very, very important. Now, my final tip will be, as much as possible, just draft or do a contract as though you'd be defending that contract in court. Now, the reason why we have certain contracts or clauses on certain contracts is not because we want to make the contract as long as possible. In fact, we have cases or instances of clients who just want a one-page contract, and I'm like, wow, that's really so short. And and that is because and it's not because that is not possible. You could actually have a 1 page or a 2 page or even a half-page contract. It's just that there are certain clauses that must be highlighted. There are certain clauses that you cannot just leave out. So, like as much as possible, you want to draft your contract clearly in a concise way, such that you are going to be, or with the mind, or with the intention that you will defend it in court one day. And a contract paper is not because you lack trust in the other party. It is because you want to state clearly what the contract should be like. You want to have a reference when an issue arises. At this point, I would be ending the talk. I really appreciate this time, and I'll be calling for questions. So just as a recap, I told you how the intellectual property assets are actually very important for any business. In fact, it's like the heart of the business. For any business, for a tech startup, for instance, the heart of their business is their intellectual property. Once they lose the intellectual property in that business, that is all. And this applies to every other business that has some form of IP assets, or the other. And you know I'm talking about, of course, copyright, trademarks, those trade secrets, patents, and all those other things that form intellectual property assets. So, and one way we have highlighted here is by using contracts to protect those intellectual property assets. And by that, we mean using specific clauses to actually just tie down these intellectual property assets. Um, without any doubt, I believe that by doing that, you'd actually have your IP protected, and you can actually do business properly. Thank you very much for your time. You can actually connect with me on LinkedIn, Facebook, Instagram, or Twitter, using um, Abba Victor Oche. So I'll be taking the questions now. So you can just send them up in chat. Thank you very much.
Thank you so please, can you type in your questions in the chat box, please? Okay, someone is asking, is taxation in Nigeria yet?
So yes, IP taxation. So a simple answer to that question would be, um so far, and based on my knowledge and experience, there is no clear legal framework. Of course, there's no legal framework for IP taxation yet. But of course, we have framework now forming to have intellectual property being used as assets for loans and all those stuff. But presently, IP taxation not yet. I think that should be in the works, but not yet. But of course, IP now can be used as assets to ascertain or to get loans and all. Just depending on how you value them, and of course how you put them out. IP valuation it's an entirely different topic. So yes, there is there is none for now. But IP taxation is something that would clearly and definitely come up very soon, because the IP terrain in Nigeria is still developing. It's still developing really, and of course, new cases and new instances are coming up every day. So I'm looking forward to that myself, and I'm also looking forward to any trend coming under such topic. That is taxation. Thank you. Okay, so there's another question here. Maybe I should just read this out.
Is there any law governing IP for startup companies?
Okay. So let me just start by saying, luckily or interestingly, intellectual property in Nigeria is governed by we have we have a working framework for intellectual property in Nigeria. And of course, since we do have a working legal framework for intellectual property in Nigeria, and that covers for any startup company that operates here in Nigeria, and that includes any startup. So as long as you operate here in Nigeria, it means that you fall under or you are being governed by those laws that we have. So, of course, like I already stated, we have the Copyright Act, the Nigerian Copyright Act. We also have the Patent and Designs Act. We have we also have the Trademarks Act. All these are legal frameworks that just help to steer the course of things within the IP ecosystem. So, of course, there are laws governing IP. We are not without laws actually. If there are no laws, then there will be no need um having such a dog, because of course whatever cannot be enforced, or yes, whatever cannot be enforced, there's no point even doing a contract on it in the first place. So I mean, yes, we have working laws that actually guide the way intellectual property is being conducted in Nigeria. Yes. So, and that includes for startup companies. Of course, most of the startup companies have a lot of IP assets in them, especially the tech startups and some of these creative industries. They have a lot of IP assets around what they do. So for some of them, you can always have copyrights, trademarks, trade secrets. Although, like I said, for trade secrets, we do not have a trade secret act per se. Um, all, all we do have is just gleanings from other laws that that that, that actually suggest that we protect trade secrets, because trade secret also falls under the intellectual property assets that we talked about. So we don't have like a trade secret act yet, but I'm sure that's something in the works. I'm really looking forward to transformation in the legal system around intellectual property. Yeah, so yeah, thank you very much for that question.
Okay. Another question: what are the risks when IP contract or assignments are drafted?
Oh, yeah, the lyrics actually mean the lyrics actually mean. Thank you very much for that question. It just means that you can lose your IP, and when you lose your IP, that's like all. That's like all. So let me like bring this home. Now your intellectual property, like the stuff you're actually creating. So just imagine that you now as a startup company, for instance. Sorry, I'm using a tech example now. Just imagine you came up with a product, and let's just call that product. Let me use your name, Kypra. Let's say you have a product called Kypra, um, and then that product actually solves a particular problem. It's a software now. Of course, for a software, there are different classifications or different strands of IP assets that you can actually find um, after you have properly done your audit and you have really gone to check. So you can actually have copyright, which covers for your codes, your APIs, and some of those very particular codes basically that you use to actually come up with that product. For trademark, since that solution or that product has a name, trademark will cover for the name of that your product, which we have called Kypra. So, and also you'd also have trade secrets, because of course you definitely work on that product with a team. So you'd want to tie things down. You want to tie your trade secrets. Of course, during the time you were coming up with that solution, you interacted with a lot of people. You had probably volunteers, you had employees, you had teammates, you had co-founders, and all those stuff. So you want to tie things down with your NDA for trade secrets. You could have patents, but that is not so common. Now, patent comes in when what you did is actually novel. By novel, I mean new. It means that nobody else in that industry have seen what you have come up with. So that's when patents come in. Well, in most cases, you don't find patents doesn't just come that easy, because you have to actually confirm that okay, this stuff is actually new. Nobody in that industry actually knows. So in an instance where your contract, or yes, in an instance where you do not properly draft the assignment clause, it just means that you can lose your IP actually. And if you lose your codes, if you lose your trademark, if you lose your trade secret, of course, you just know you have lost whatsoever you're building. And that's why personally I advise that some of these checks are being done, because you can't claim to have something when you don't actually have it. And in Nigeria, what works is that once you have not owned these things, they are not actually yours. And one way you can own them is by first registering them, of course, by registering them, and then making sure that you have complied with all those agencies, all those laws that you should comply with. Of course, the recent case of the recent case of Zap Africa and Paystack that has been trending. I think the case is still in court. That has been trending for some time now. So Paystack came up with a product and called it Zap, and Zap Africa just thought that okay, that was infringing on their trademark, so they sued. Now the issue is still ongoing, but it just shows that you could actually lose what is yours if you do not carefully take care of them. So if your contract is properly drafted, of course, the worst case that can happen is that you will lose your IP rights. And when you lose your IP rights, you lose your product, you lose every of your effort, you lose every of your contribution to that product. So you get to just lose entirely. That's what it is. Yeah. So I hope that that answers your question.
Yes, thank you. There's another question. What happens to confidential data after the contract is over? Must it be returned or deleted?
Yes. So this like I usually say, everything is possible. It just depends on your contract. So if the contract says after the contract is over, the confidential data should be returned or the confidential data should be deleted, then of course what the contract says is what would happen actually. Now it gets to a point where the contract paper is even more stronger than the law itself. So and that just shows the power of an agreement. So in an instance where, for instance, you tell somebody something about your product, which like forms a trade secret, of course, there is possibly no practical way that you can actually delete that thing from that person's head. We're not like machines, we're not computers where you get to do an auto delete or format someone's brain such that they cannot remember anything. Of course, that is like on the base level of it. You don't expect people to just forget things just like that. I'm talking now on the normal base or on the normal course of things. So in an instance where there is confidential data, which like forms for your trade secrets and all those stuff. When the contract is over, whether or not it must be returned or deleted is dependent on what is written on the contract paper. And that is why a contract should be clear as much as possible as to the aftermath of the contract. Now, on the contract paper, most times, it is usually indicated that certain clauses of that agreement subsist the termination of the contract. So it therefore means that even after the contract is over, the certain clauses on that agreement still continues. So in this instance, you want to make sure that, okay, since this is your confidential data and this is what makes your business run, this is what makes your business thrive, you want to make sure that a clause is being put there to state clearly that after this contract is terminated, after the transaction ends, such confidential data is still being kept as a secret, or is still being or is being deleted or is being returned, depending on the instance that the transaction works. I hope I was able to answer that. Um, so are there any other questions? Um,
Is there any other question? You can kindly put it in the chat box.
Hi everyone. So while we still wait for some more questions to come in, I just want to remind you all that for us to send your certificates, it's important that you mark your attendance. So I had posted earlier the link for the attendance, but I've just posted it again so that you can just go there and then let us know that you attended this webinar. So I mean, maybe we'll just give a few minutes for questions, but in the meantime, I just want to use the opportunity to thank Mr. Victor for the time that you spent with us and for all the insights that you shared. They've been really valuable. I'm sure that everyone that's participated today has learned a lot. Um, we'll definitely be rounding up very soon. Of course, if any questions come up after we've we are done with this workshop, you can always either send them to the group or you can send them to um, our email handle. So that's at community@ramen.legal. So I'm just typing that in, community@ramen.legal. Yeah. So please do make sure that that number one, you mark your attendance. Number two, if there's any questions that arise later on, you can post them on the group or send them to that email address. And then someone was asking earlier about the recordings for the session. So yes, we will make the recording of the session available to you as soon as possible. And also the slides that were shared during the presentation, we'll also try as much as possible to get those slides over to you. Okay, so in the absence of any further question, Precious, would you want to add anything?
I actually don't covered everything.
Sorry, can you come again?
Sorry, please, can you hear me?
Yes, we can hear you now.
I really don't have anything to add, but I think he covered lot, a lot of the use of special clauses that are making sure that your contract is not rigorous. So I think he hit the nail. I really don't have any.
Okay, wonderful. So I just want to also announce that so we are going to be thank you so much, Victoria. So we're going to be taking a sort of break for a while, not too long, but just to give us a chance to restructure, reorganize. Previously, we had a few technical issues, and that's why we had to move to Zoom. Um, so we just want to spend some time to clean out a few things before we resume our workshops again, because I'm sure these workshops have been very helpful to most of us. And but definitely, we will definitely communicate when the next of such workshops will be. And also, but besides the workshops, one of the things that we'll also try to do is have question and answer sessions with some of the lawyers that are in our network. So I'm pretty sure that some of us might have questions that go beyond the scope of what we are particularly talking about. And you might want to ask questions concerning different other things as it pertains to the legal aspects of your business. And so we'll put that together and then we'll let you know when that session will be and who will be in that, or which of the lawyers we will have as part of that session. We might have a number of them together in that session so that they can answer different types of questions in different areas. Okay. So once again, as we round up this session, I want to say thank you all so much for participating again, even though we changed the time I do hope that this time was more favorable for most people. If you want to maintain the time, let us know. If you'd like us to go back to our original time, um, also let us know. And then, yeah, I would also remind you about the test, that legal test that we posted. Okay, we'll also post the link on our group so that you see it. But then, if you can, just spend, it's just about literally like 5 to 10 minutes to just go through that test, and then let us know which areas within your business require legal support, so that we know how to help you. Thank you all so much. Um, okay, so Abdul Rahman says, let's maintain the time. Okay, so if we can get more votes, maybe we'll put a poll on the group. Okay, Precious, we'll set up a poll on the group. Let's get votes and see which time is more favorable for everyone. Okay, so um, thank you all so much for joining. I wish you all the best in your coming week. I yeah, all the opportunities and favors that make your business thrive. I pray that God is sending all of them to you this week. Um, yeah, so I'd like to thank all of you for coming. And until next time, you'll be hearing from us on the group though. Until next time, have an amazing week. Okay. Bye bye.